Hey, what's going on? It's Scott. I worked in law enforcement for several years, and here is part two, highlighting some of the interview I had with police legal instructor Zach Miller with Blue to Gold Training. Let's get right to it because I believe the more educated police are, the more educated the citizens are, the better the interaction can be. Now, when it comes to plain view, what do you teach officers regarding plain view versus something illegal seen in plain view in a car versus something seen in plain view in a house? Say you went on a domestic, you look in the window before knocking on the door or something because you hear screaming and you just kind of want to get a better idea as to what's going on before you knock on that door, and say you see something illegal in the living room. There's a big difference between automobile and house. What do you tell officers? And I know we could talk about this for a while, but what's kind of like the basics you would give?
Basics. Okay, yeah, we can keep it on a surface level, but a very good question. So a lot of times officers confuse a plain view sighting, which is what you're referring to, with the plain view doctrine. The plain view doctrine is a very specific exception to the search warrant requirement. The plain view doctrine allows you to seize items that are in plain view when you have a right to be where that item is in the first place. Okay, so one of the elements of the plain view doctrine is before I can go take this item that's in plain view, I have to be where that item is lawfully as well. So when it comes to a home, knocking on the door, just like you said, and I see something inside the house, yes, it is in plain view because I can see it. I don't need any kind of sensory enhancement tools. It's right there. But I can't just, in order to seize the item, I've got to be in the house to get my hands on it. In this case, the plain viewing doesn't get me inside the house. I need either a warrant to go in, a search warrant to go inside the house, or exigent circumstances, which we could articulate potentially in a case like this. There could be exigent circumstances, but the burden is going to be on us to articulate that belief, or consent. I would need consent to come inside the house. I can't just open the door because I see narcotics inside the house, walk in and seize those narcotics without a warrant. Now, in a car, it's the same principle. I'm outside of a car on a traffic stop and I see narcotics or contraband inside the car in plain view. The plain viewing doesn't let me go inside the car. I still need a warrant or exigent circumstances or consent or some exception to the warrant requirement. And with cars, we have a beautiful exception to the warrant requirement, which is the Carroll Doctrine. So in this case, it's actually the Carroll Doctrine that gets me inside the car. The plain viewing of the narcotics or the contraband gives me the probable cause that I need to go in the car, and Carroll gets me in there without having to get a search warrant.
Can you elaborate on what the Carroll Doctrine is?
Carroll Doctrine comes from a case from in 1925. It's one of the oldest Fourth Amendment cases, not quite the oldest, but close. And we learned that the Supreme Court tells us that when it comes to mobile conveyance like vehicles, there's a built-in exigency to that. So when a vehicle can be easily moved from place to place rather quickly, and once we have probable cause to believe there's evidence or contraband in that vehicle, the Carroll Doctrine says, for the most part, we're allowed to search it without a warrant due to the built-in exigency of the situation, the fact that that vehicle can be moved quickly while we go get a warrant and hope that it's still there when we come back. So the Carroll Doctrine, there's been a lot of expansion of Carroll since it came out in 1925. But that's basically the gist of it.
All right. Well, this is going to sound so basic. It sounds stupid, but I just don't know who's listening and what they know or don't know. If someone is ordered out of a car and they consent to, say, a pat down or a search of their person, and something illegal is found on them, does that give the officer right to immediately search their car?
Oh, not automatically, but it's going to depend. Every situation is fact specific, and I know that might sound like kind of a cop out answer, but it really is true when it comes to the Fourth Amendment. Facts matter. Yeah.
Right.
So I would say as a general rule, it's probably going to lead to a search of your vehicle, particularly if it's your car. So let's say we get someone out on the driver steps out of the vehicle. We search them consensually. We find narcotics in their pocket, something that very frequently occurs. We find narcotics in that person's pocket. Well, the question we must ask ourselves then is, does that give me probable cause to believe there is additional contraband inside that vehicle? Because if there is, then the Carroll Doctrine lets me go and search it without a warrant. So we would ask, whose car is it? Obviously, if it's that person's car, that's a strong factor to making it reasonable to believe there could be more narcotics in their car? Are there other signs of drug use or that contraband in the car from where we can see it? Why did we stop the car in the first place? Has the person made any incriminating statements? Do we know anything about their previous history involving this particular item we found? So in many cases, it's not an automatic, but it is a strong factor towards being able to search the vehicle as well. Yes.
When can an officer arrest someone based on probable cause of a misdemeanor that occurred outside of the officer's presence?
So this is going to be a state-specific answer.
Okay.
This is state statutory law is going to answer this question. I can speak for Virginia because I live and work in Virginia. In Virginia, the general rule for us is misdemeanors that don't occur in the officer's presence, which is many times, we have to get a warrant first, an arrest warrant. Then we can make the arrest. Now, there's exceptions to that. There's the obvious domestic assault and battery. We get called to a house for a domestic assault and battery, determine one of them is one of the parties is committed the offense, which is typically a misdemeanor offense. It doesn't make sense that we would have to go get an arrest warrant and then come back and arrest that person because of the volatile nature of the situation. So that we can make a warrantless arrest for. There's a whole list of them. But the answer is going to be found in state statutory law, your criminal procedure statutes. Some states allow for warrantless arrest for misdemeanors that don't occur in your presence, but many of them restrict that to only those that occur in your presence. And then some of them require you to write a citation and release the person as opposed to taking them to jail for misdemeanor. So significant variation from state to state here procedurally.
Okay, I came across a video on one of the auditing channels. It led to an issue. Can an officer seize someone's phone if that person was recording a crime that officers are investigating? And then what if the person refuses to hand over the property?
This is a touchy subject. If it's a serious crime and you have probable cause to believe that that person's cell phone contains relevant footage of the offense, then yes, you can seize the phone without a warrant. It would be assuming the person is in a public area and you have you're interacting with the person right now. They're holding their phone, for example. It's actually the plain view doctrine would allow you to seize that phone, but you've got to have probable cause to believe they actually recorded the event and that it's going to be relevant. If it's duplicative evidence, like if you saw it occur and you like for yourself, then there's no need for you to have the video footage of it. I would tread very lightly in this area with officers. Serious offense, probable cause to believe it contains relevant footage of that crime, and you have access to the phone, then yes, you could seize it without a warrant. I think a lot of officers do it more as in spite, to spite the person or as kind of a retributive type of an action. And I certainly think we can't do that. I know we can't do that.
Right. Yeah. No, please, by all means, if you have that thought, just don't entertain it.
Yeah. Just request the, get the person's information, ask them what they saw. But if they don't want to turn over their phone, then, absent those things that I mentioned, then let them go.
We got an election year 2024. We're not going to talk politics. We're going to talk on pretty much the safe predictability. There's going to be some protests throughout the country, and
no doubt. Right.
Yeah, no doubt on that one. But hopefully they don't turn into riots. But my concern is I would hate for an officer to get in trouble because they get the two mixed up, where someone's exercising their freedom of speech versus what is actually disorderly conduct. So can you kind of give officers some bullet points to be aware of in the midst of this climate we're in?
Protesting and protected activity under the First Amendment, both under the freedom of speech protection, also, and then the right to assemble peacefully. But disorderly conduct is a really touchy type of an offense. Most states have some version of disorderly conduct. Words alone, it's not a crime to use profanity. It's not a crime to insult people. Not all speech is protected under the First Amendment. Most is, but there is what's called the fighting words doctrine that the Supreme Court has said true fighting words are not protected speech. This is where a disorderly conduct charge could come into play. When I talk to officers about disorderly conduct, I teach them that in order for words alone to be disorderly conduct, there has to be an imminent assault and battery that is likely to occur unless you address it immediately. So just threatening to beat someone up is not disorderly conduct, but threatening to right now I'm going to beat you up, and they take a step towards you or they raise a fist, they somehow physically manifest the intent to follow through with that threat, that can be disorderly conduct. Although you're arresting them for the words they say, it's also their actions that say they intend to follow through with that threat. But just some broad overarching threat or just abusive language is not disorderly conduct. There has to be some kind of physical act that accompanies the words in order to take it out of the protected First Amendment area and into areas that states can criminalize. It's called the fighting words doctrine. I believe the Supreme Court case that talked about this case called Chaplinsky versus New Hampshire from 73, something like that. But I believe that's the correct name of the case. But yeah.